Hi, my name's Walt Carfora, and I'd like to discuss an important issue in Social Security disability cases today: how the judge determines disability. Disability determinations have very little to do with the real world. The Social Security Administration looks only at whether you're capable of doing jobs, not whether you would be hired. Thus, you may have to prove that you're unable to do jobs for which you'd never be hired. In some cases, the medical findings about your condition alone will cause the judge to find you disabled. In other cases, the majority, will usually have to prove two items. One, your medical impairments prevent you performing any job you've done in the past 15 years. Two, there aren't many other jobs you're capable of doing considering your age, education, and work experience. Think about all the jobs you've had in the past 15 years and pick out the easiest one. We have to prove that you can't do that easiest job, even if we're certain you'd never be hired for that job again, even if the company would no longer exists, and even if the job no longer available elsewhere. Proving the second item, that considering your age, education, and work experience, you're unable to do many other jobs, is even more complicated as opposed to common sense. In many cases, we have to prove that you're unable to do jobs that we know you would never actually be hired for. This doesn't mean you have to be unable to do anything. In fact, very few people who go in front of an administrative law judge are unable to do any job at all. This is an important point to grasp because one way to determine disability is by figuring out what you can do. Then we can determine whether or not jobs within your capacity exist in significant numbers in the economy, considering your age, education, and work experience. We do that by either looking at a fairly complicated set of rules, or in some cases we ask a vocational expert. The rules that we use for determining disability apply most directly to impairments that limit your physical ability to sit, stand, walk, lift, bend, or work with your hands. Mental impairments are important, but they're a bit more complicated. If you're unable to do certain kinds of manual labor, whether because of a back problem, heart condition, breathing problem, or some other medical condition, your lawyer will be able to look at the rules and figure out what you need to prove to win your case. Here are some examples. If you're under 50, the general rule is that you have to prove that you can't do an easy sit-down job, or even a job where you're allowed to alternate sitting and standing during the workday. You have to prove this even though you may not be hired for such a job. If you're 50 through 54, the general rule is that you must prove that you can't do light work. In other words, work that involves being on your feet most of the day and lifting up to about 20 pounds. Thus, even though you may still be able to do a sit-down job, a desk job, you can still be found disabled. If you're over 55, it gets even easier. The general rule is that you must prove that you can't do medium work, that is, work involving being on your feet most of the day, frequently lifting 25 pounds and occasionally up to 50 pounds. So even if you you can be capable of doing light work and still be found disabled. These issues can get complicated when you had jobs in the past where you learned a lot of skills. The judge will want to know about your work skills, and you have to be able to explain them to the judge. How do we go about proving all of this? We do it at the hearing through your answers to the questions from the judge and your lawyer. Hope you found this information to be of assistance. If you need help with your Social Security disability claim and you live in the Tampa Bay area or elsewhere in Florida, here's my contact information.